Let me go now to Representative Fred Cox.
Thank you, Mr. Speaker. Motion to encircle.
Motion to, will you state the bill number and the
Sure.
title?
Motion to encircle HB101, second substitute, disabled adult guardianship amendments.
Motion is to encircle second substitute House Bill 101, disabled adult guardianship amendments.
That is
Would you like to speak to that motion?
I will. We circled this the other day so that we could prepare a third substitute, which was requested by one of the parties. After looking at the third substitute, they decided they liked my idea with, well, the third substitute didn't go over as well as the second substitute, so I just would like to present the second substitute.
Thank you. Discussion to the motion to encircle. Seeing no lights, I'll place the motion. All those in favor say aye.
Aye.
Those opposed say no. Rule that motion passes. The bill is encircled and before us. Representative Cox.
Just a quick explanation. The second substitute has a sunset in the bill. The third substitute has a delayed implementation. Going back to the second substitute, what the problem has been is we have individuals that have been taking care of their children since they were born. And these children, in many cases, are now 20, 30, 40 years old. In the past, many of our doctors and many of our insurance carriers or whatever would kind of look the other way as far as some of the privacy rules and some of the other requirements when their children needed medical care. That has become increasingly more difficult, particularly in the last couple of years. So we have parents that are struggling to make ends meet because their special needs children need a little bit more care than somebody else. In many cases, these children cannot communicate well, and they need constant care. What needs to happen is they need to have a guardianship in place. And once they have the guardianship in place, the doctors, the other medical individuals then have the ability to allow them to keep on taking care of their adult children. So what the bill does is try to reduce the barrier for that to happen. Last year I ran a similar bill, and one of the provisions was put in another bill, and it is now law, and that is if the person looking for guardianship is the either natural parent or foster parent, or not foster parent, adopted parent, then we reduce the $360 filing fee down to $35. So we're not proposing to change that. That has been one of the barriers that has been fixing it so the parents would not be able to get the guardianship in place. The second one is these parents try to go through our myriad of laws and websites and forms and everything on their own because they don't have the money for an attorney. So they do it pro se. And they find out that not only do they need an evaluation from a doctor or some other things, but they need an attorney representing their adult child. They have to pay for that, or it comes out of their adult child's whatever resources they have. In many cases, they don't have much at all because they can't work. That's the reason that there's a guardianship needed. So the parents are trying to do this, and they're paying $250, $2,000. They're paying different amounts. There are some programs to help solve this, and one of the reasons that I have a sunset is to allow some of these programs to actually start working. But in the meantime, these parents will be able to, if you look on line 74 through 83, which is the bulk of the bill, the attorney for their adult child may not be required, and there's a big may there, if it's the biological or adopted child of the petitioner. This child doesn't have a lot of assets, so we're not having somebody taking advantage of somebody with assets. The person has the ability to appear in court. Now, that can't happen all the time, but it can happen many times. And some of these adult childs of these petitioners do have the ability to answer questions. And if they don't like something, they're perfectly, they have the ability to respond. So 80 and 81 is key. The person is given the opportunity to communicate to the extent possible, the person's acceptance of the appointment of the petitioner, and then the ultimate decision is up to the judge. If the judge is satisfied that counsel is not necessary, they can basically agree that counsel is not required. They can rule on the merits of the case that they're presented, or the judge can basically say, I'm not comfortable with the situation, go get an attorney. The person can say, I don't have the resources to get an attorney. And the judge can say, either we're going to appoint someone, or, by the way, here's this group that will provide some free legal help for you. But right now, we've got a problem. The state's website is not user-friendly in this area. The forms that they are oftentimes needing are not on the state's website. The forms that say, I need an attorney, do not point out that perhaps one could be appointed for little or no cost, even though it is buried in the website somewhere. There's lots of problems, and if this problem hadn't been happening just today, I wouldn't be running the bill. But the reason I ran it last year, and the reason that we had a good sponsor from West Jordan, a senator, the year before, and other people working on this issue, and a representative from Davis County that's been working on this issue, is this has been a barrier for parents. The purpose of this bill is to remove the barrier, come back in 2 years, and see if the other possibilities, the other groups, the other volunteers are all in place, the website's fine. Maybe this bill will not be needed in 2 years. But in the meantime, it is needed, and I appreciate your support.
Thank you. Discussion to the bill. Representative Edwards.
Thank you, Mr. Speaker. I actually did have, I have just a comment. I did run a bill on this issue last year or the year before, and decrease the filing fee for families who are in the same situation as the bill sponsor has described, and have kind of been working with some of the folks as 101 has moved through the process a little bit. I think that the bill sponsor has been sensitive to many of the concerns there and tried to find a balance between the right to counsel for these individuals who are in extremely vulnerable situations, as well as making it an easy and as seamless as possible transition for the families. I think that the sunset allows for the maturation of the guardianship signature program, and at the date signified on the bill, we can look at this program again and say, is it robust enough that it's actually meeting these needs and doing what it's supposed to? If so, great, then you know, the bill would go away and we'd be in great shape. The main thing is that we're just trying to meet the needs of the parents and families here, and I think this bill moves us in that direction. Thank you.
Thank you. Further discussion. Representative Snow.
Thank you, Mr. Speaker. The sponsor, the good sponsor, has been working on this issue for well over a year, has brought several drafts to judiciary, and has been willing to listen to a lot of my comments, and in fact, some of the changes in the second substitute were changes that I recommended. In order for the body to understand what's at play here, I'd like to just share an example with you that happened in my practice and in my neighborhood. Family that lives close to me with limited means and resources came to me and said, you know our daughter, and in fact I did know her. She raised in our neighborhood from the time she was an infant. She's now 18 years old, going on 19. And this family encountered the very thing the sponsor indicated, and that is when the parents had been acting as unofficial guardians all this time, but suddenly with the law changing, medical providers would no longer accept their parent status. They had to have a guardianship. So they came to me, limited resources, and I said, I'll tell you what, I'll do this at a bare minimum. But think of this. This is parents that had raised that child from infancy, who knew that child better than any other person, did not have a lot of resources, and we had to go to court and go out and retain the services of another attorney to come in and tell the court what was in the best interest of this child, and tell the parents what was in the best interest of the child. I know I've heard from colleagues from the Utah State Bar, as well as the sponsor has. They don't like this. I don't know that they don't like it because they're trying to protect their turf. In a perfect world, every person in court would be represented, but we no longer live in that kind of a situation. We have the courts that are providing access to the self-represented every day. And in this case, we're asking for an allowance, a small, narrow allowance, that when parents of that kind of a child go to court to have that guardianship, that if anyone can represent to the court what's in the best interest of that child, those parents can. It also has a safety provision, as you all know, that if the court doesn't feel comfortable in something in the proceedings, the court can always revert and say to the parents, you need to go through the full procedure. You know, a few years ago, the Supreme Court, when I was more involved with bar governance, the Supreme Court took on the issue of delivery of legal services. And the bottom line was that a lot of legal services were not being able to be obtained by lay people because of the cost. And one of the things the Supreme Court did is adopt Rule 13 in the rules governing small claims court, which is interesting. And the reason I point that out is the rule actually provides for someone who is not a lawyer to represent a party, as long as that person doing the representation is not compensated. Now, why did they do that? They did that because they recognized that there was a need that lay people, particularly people that do not have a lot of resources, are not obstructed from access to our judicial system. So I compliment the sponsor in this narrow proceeding, providing a way to look out for the parents of children that need those special needs and need a guardianship but may not have all of the needs that are required in order to hire all of the counsel, including special counsel, just to represent the needs of that child in this particular situation. I would ask for the support of the body. Thank you, Mr. Speaker.
Thank you. Further discussion. Representative Brian King.
Thank you, Mr. Speaker. We did hear this in judiciary a number of times, and I appreciate the fact that the bill sponsors made a lot of effort to address the reasonable concerns that were conveyed to him by us as committee members and by others within the legal community and outside the legal community. And I have to still tell you that I am uncomfortable with it for this reason. I just haven't found that there is enough of a problem presented to justify eliminating the obligation to provide individuals who are disabled with their own independent counsel in these circumstances. We know that there are no-cost and low-cost options available for these individuals, these families of these disabled individuals, to have outside counsel retained to represent the interests of the disabled person. And I don't have any question that in 95% of the circumstances, parents who are looking for an appointment of guardianship for a disabled minor when they turn 18 and become an adult are in fact doing a good job of looking out for their children's best interests and will be competent and will not be overreaching. But I also recognize that there are going to be a number of those individuals who lose perspective and who believe in less of an independent relationship between themselves and that disabled child than we would want to see. And they need to recognize that that disabled child has independent rights to be represented and to have an argument made on their behalf. And so I think that under the circumstances, this is a bit of a solution in search of a problem. And although I do appreciate the hard work that our bill sponsor has gone to in coming up with something that is acceptable, I'll have to be voting no on this.
Thank you. Further discussion. Representative Powell.
Yes, Mr. Speaker, I'll be brief. I know we could go on for a long time, but it's obviously a situation that some people have seen. So I've represented several incapacitated people in this instance, and I cannot tell you how upsetting it is to the parents that they have to obtain counsel, and I typically just do it for free. In a small town, it's easy for an attorney to find another attorney and say, hey, we got this going on. Can you show up at court? Make sure you interview, do whatever you need to. It is an odd situation, and I don't want to make anybody's decision for them, but because of the safeguards that are put in the bill, I just wanted you to know that having had experience with this many times, I will be voting for the bill because I don't want to have those parents ask me again in the future, now why do we have to do this with our own child? So I think it's a good balance with the safeguards that are in it, and I will be supporting the bill.
Further discussion. Representative Tanner.
Thank you, Mr. Speaker. I, too, have represented people in this situation. In particular, I've represented some of those incapacitated children. There's quite a range, and I just would like us to be aware of that. Some of them are quadriplegic. They haven't ever gotten out of bed, and it's not an issue. It has to happen. It has to happen one way. But whenever these cases come up, the rule is that you are supposed to make the least intrusive order in that child's life or that adult's life as is possible. The simple thing to do by checking the boxes is to simply say, yes, this is a complete guardianship. The parent is going to have all the rights over the child, and thank you very much, we're done. The hard part is to evaluate what the child is capable of doing and reserve in a legal sense as much legal autonomy for that child as it can have, he or she can have. I've had them that are so terribly disabled that it's not an issue of any kind. I've had some that are just marginally, it's a case of autism or it's a case of some kind of mental retardation. And in those cases, it's a much harder call. And those children need somebody who can speak for them and negotiate for them, because otherwise it's much too easy in these cases to check the box and say they need a complete guardianship. For that reason, I've got some concerns. I do appreciate the intent. It costs maybe $500 usually to get somebody to represent the child. And I want us to be aware of that in considering this bill. I'll be voting against it, but not because it's a bad idea in every case.
Thank you. Seeing no further lights. Representative Barlow.
Oh, thank you, Mr. Speaker. I'm supportive of this as well, but I have one question, and that is not with language.
I'm sorry.
Would the sponsor like to yield
to a question?
I would be happy to.
Proceed.
Oh, thank you. So this applies on line 69 to, and in the category B, a intelligent quotient score under 20 to 25. Can you clarify that for me?
That's a great question. There are several areas of this bill, and I realize that it's 3 pages, but the area on the end, 74 to 83, basically stand to a large extent alone. If you look at, for example, you look above there, there's a C, and then you get a B again. That B goes with the other A. You start backing up, and you're really looking at 5A, and 5A specifically says the person alleged to be incapacitated shall be present at the hearing in person, see all evidence. Anyway, it talks about more things than just individuals with an intelligent quotient of 20 to 25. We originally in this bill had a quotient of 50, but those numbers are easier to obtain for individuals that are perhaps 18 that are just getting out of a high school specifically to help individuals with special needs. But somebody that's perhaps 30 or 40, they don't necessarily have those numbers. And so I do not believe that it is limited to just the individuals in that score area.
If I could respond. This is a small point, but while we're in this code, this is a thing that I think we could fix very quickly today with your bill. I mean, it's either 20 and under, or it's 25 or under. And this is just one point of among multiple qualifiers. But it can't be both 20 and under and both 25 and under. So I would recommend, if it would be appropriate, to maybe use 25 and under and clean up the language.
So if somebody, what you're saying, if somebody were to delete the words 22, and so it would just say an intelligent quotient score under 25, the existing law language would be more clear.
Exactly.
If somebody wanted to make that motion, I certainly wouldn't object.
Thank you. Further discussion to the bill. Representative Ivory.
Thank you, Mr. Speaker. Motion to amend.
Motion to amend is in order.
I'd like to, on line 69, delete the words 22.
The motion before us is a motion to amend. It is to strike on line 69 the number 20 and the word to. T-O. Would you like to speak to that?
No, I think the good representative from Davis County did that very adequately.
Thank you. Discussion to the motion to amend. Representative Cox.
I always like things to become better.
Further discussion. Back to the maker of the motion for summation. Maker of the motion for waive summation. All those in favor say aye.
Aye.
Those opposed say no. Rule that motion carries. The bill has been amended. Further discussion. Representative Stratton.
Thank you, Mr. Speaker. Would the sponsor yield to a question?
Will the sponsor yield to a question?
I would.
Proceed.
Thank you. Appreciate the work that the sponsor has done on this. The question is, I know that you are working with some of those that this would apply to in the disabled community. Just want to see how those have gone, if their concerns have been satisfied. I know that previously there was a concern on being engaged in the constitutional rights of individuals that may be infringed upon. Could you comment on that?
I would love to. One of the reasons I'm running the second substitute as opposed to the third was because they're working very hard to get the website, the forms, the process, and these volunteers up and running. They're hopeful that within the 2-year period of time that they'll have that. We wouldn't even need this particular statute because they will have dealt with it. Their concerns that they've raised has to do with the right of counsel, either based on the 6th Amendment or the 14th. I asked them if they have any case law of that to defend that concern, and they don't. Apparently that hasn't been ruled on by a judge, other than perhaps some other items that had been mentioned earlier by the good representative from southern Utah. So I went and talked to the drafting attorney, and I specifically asked that question. Is there something in the 6th or 14th Amendment that we are violating or anything else? And her reaction was no. One of the main reasons that we are first allowing a judge to make the decision, what I had last year was kind of an automatic. The judge wasn't making that decision. But to protect the 2% or 5% of the cases where perhaps somebody doesn't have the child's interest at heart. We've got the judge having to rule on that situation. And then the second thing is to have the individual themselves be there. And those two, along with the other recommendations from the good representative from Southern Utah, were specifically put in there to make sure that we have a good process for these individuals. And again, the purpose of the bill is to remove a barrier, and these other groups are working very hard to get a non-legislative solution to the problem solved, but they agree that they're not there yet. And the reason that they opted for the sunset as opposed to the delayed submittal, and not that they really like either one, or the delayed implementation, is they like the idea that we will have to come back in 2 years and get rid of the sunset or extend it, because they're hoping that within that time period they will have all of the things that they've been working on for the last year or so in place. So I have been working with them. Are they thrilled? No. But given the two choices, they're opting for the second substitute, and that's the one I'm running.
Thank you, Mr. Speaker. May I commend the sponsor for the effort and work. Thank you.
Thank you. Further discussion? Seeing no further lights, we'll come back to sponsor for summation.
Thank you, Mr. Speaker. I appreciate the time. I realize I've been working on this for over a year, and others have been working longer. We have tried to craft the smallest solution possible to help individuals that really can't help themselves, that because of our legal system, primarily our laws having to do with medical records and privacy, many of which coming from the federal government, these parents need our help, and I ask for your support. Thank you.
Thank you. Voting will now be open for second substitute House Bill 101, Disabled Adult Guardianship Amendments as amended. Representative Daw, would you like to vote? Seeing all present having voted, voting will now be closed. Second substitute House Bill 101, having received 64 yes votes, 9 no votes, passes this body as amended and will be transmitted to the Senate for its